for Enugu.
Hello and welcome to today's edition of your number one program on television, The Law and You. The Law and You is a program designed by the management of Adobe Broadcasting Service to inform and entertain our viewers. And from here, of course, we'll look at the law in totality. That is how I welcome you to today's edition of the program, The Law and You. I remain your host, Oliver Ijogbe. Today, we'll be looking at one very important issue. I mean, it's an issue that has been bothering so many persons. And it's one issue that, of course, when you go to the court, of course, you'll find it there. You know, the High Court, to the Court of Appeal, even up to the Supreme Court level. And so today we'll be looking at land acquisition. Land acquisition. You will agree with me that land as a topic has caused a lot of legal battles. And so today we'll be looking at that very issue, with a view to educating members of the public. Once again, you're welcome. I'm not alone in the studio. I have two gentlemen that will be doing justice to this topic. I have Ebosele Oifo. He's a Benin-based legal practitioner, and he also serves as the publicity secretary of the Nigeria Bar Association Benin branch, otherwise known as the Lion Bar, and presently is also a member of the South of the bar. Ebosele Oifo, you're welcome to today's edition of the program.
Thank you, Olivia. Good afternoon, viewers at home.
I also have Jonathan Anrua Esquire. He's also a Benin-based legal practitioner. He once served as the secretary of the NBA Benin branch, and he also served as the PRO of the branch. Jonathan, you're welcome to today's edition of the program.
Thank you very much, Oliver Ijogbe, and I thank viewers for having the patience to actually watch us.
So without wasting time, viewers, I want to urge you to stay by your television set because you have a lot to gain, from today's topic, land acquisition. So without wasting time, Ebosele Oifo, can you please educate our viewers how can land acquired under the customary law?
Well, when you acquire land under the customary law, there are procedures because that is mostly the major thing is that it's not written. It's called as acquisition under the native law. It's not written. But then the law says that there must be weaknesses to the transaction. You understand?
But did the law specify how many persons have come?
No, it didn't specify how many persons, but the law says that when you acquire land under customary law, because you remember our forefathers, they didn't have the benefit of maybe writing documents here and there. You understand? So land that were bequeathed to people years ago, over 100 years and all that. So the issue then, because of the issue of scarcity or maybe not enough lawyers then, or like now you go to the villages, you see that there's always this customary transfer of land from one person to another person and all that. But what the law says is that when that kind of thing takes place, there must be weaknesses to witness the transaction. Then it becomes customary. It's normally unwritten. It's not written down. That's acquisition of land under the customary land system. Okay. You understand? So that's for that.
Okay. Jonathan, is there anything you also want to add?
Well, I agree with my learned friend. Customary acquisition of land has to do with the acquisition of land under the native law and customs of our people. Writing is quite alien to our culture, and most of the lands that were acquired those days, they were acquired orally. There were no documentations as they are now. So when you acquire a land, it is sufficient if the head of that community, depending on how they give our land, if the head of that community and the elders, if they approve of it, you become automatically the owner of that land. some will tell you that you pay us with cowries. Those days it used to be cowries. You don't have this naira and kobo, so you pay and you become the owner of that land. They will begin by giving you a pointer. You go and point the land to you and ask you to actually do the requisite things that you needed to do. Mind you, I said it's always orally, and it wasn't documented. Even today, they still operate almost like that. When you go to a community and say, I want to build a house, and that land is a communal land, that's a community land, or it's a family land, they will just give it to you. And when they give it to you, then you cannot go ahead to do the documentations. So land acquisition that time could also come by way of conquest. You see a particular community going to lay siege on another community, fight it with superior power, and take over the land of that other community. It was usually so during the period or times that you had empires, the Benin empires, the Oyo Empire, the empire of the Ife Kingdom, that's Oyo Empire, where you have Oyo of Ife. Then you have Jaja of Opobo. You have so many of those kings that were in charge of those empires. If you go and you have more power, then you conquer that place. And once you conquer it, that was then, not now, you become the owner of that land and the people. Therefore, you will not be in charge of the giving out of land, the partitioning of those lands, and the alienation of those lands. That is giving out those lands to would-be buyers or for whatever purpose they want to use it for. If it is for the building of a house, the procedure might a little bit be different from when you want to use it for land, for farm. In most cases, they'll give you farmland. They regard you as a tenant, a customary tenant. That when we are willing to use this land, we'll take it from you. Then, of course, the reversionary interest on that land belongs to the community. They have a lien over that land. That is, they have power that over that land, which makes the land reversible. That is to say, the title of that land reverses to the community. So, the very good case in that regard is Idudu and Okumagba. I think that is the locus classicus. The first time that the Supreme Court, when we say locus classicus, that is the foundation, the beginning of the principles that relate to the acquisition of a customary land. The Supreme Court made it very explicit, the various ways by which you can acquire land customarily. So, some of these ways I have itemized are those ways by which lands were acquired those days. And it stands to date. If you trace your root of title very well, you discover that it dates back to time immemorial. It dates back to those days. It could be 300-400 years ago. Somebody said this is my ancestral land. He knows what he's saying. He's saying that his father, himself, his father, his great-grandfather, up to 10, 5, 6, or 20 generations. I don't know how to put it.
Okay.
They were there.
Yes, Jonathan, let's leave out the way, of course, land, it's been acquired under the customary law. Let's now look at how can land be acquired under the English law.
Well, under the English law, the law he just quoted in Idudu and Okumagba, which is a locus classical on how to acquire land, is stated there that when you want to prove that you are the owner of land, one of the ways is by production of documents. So under the English law, of course, it has to be in writing. It should be in writing, weaknesses here and there and all that. So, but most importantly, it will be in writing. So that's another way, that's a way of acquiring land under the English law. So if, it's like what is happening these days now, you go into a community, you say you want a land, somebody comes out to say, okay, I have maybe 100 by 100, or I will have an acre, I have 60 acres, I have 1,000 acres and all that, then you negotiate with the person under the English law, you negotiate with the person, a price is agreed, then he gives you the document, his own document of title. Most times, if he acquired it through customary acquisition of land, it means he will not have paper, but there will be evidence there that he's the owner of that land. Then it behoves on him now to transfer the land to you. So he becomes the vendor. He's the vendor while you are the vendee. You understand? So he's the one that is going to transfer to you as a transferor. You become the transferee. You understand? So it's not documented. He will sign, you will sign. Receipt will be given to you. Payment of money will be made. So that's acquisition of land under the English law. It must be documented. Okay. Unlike the customary law where there's no written document. It's just that there should be a witness that transaction. Okay, that's the major difference between the English and the customary law system.
Okay, so and Jonathan, I would like you to educate members of the public, because this is an interesting topic in that so many persons, at home who are viewing us right now will benefit so much from. You listen to what Obosola Efo just said, and I want to find out from you. If, for example, I have 100 by 100, and I want to sell 50 by 100 to another person, I have the original document, and I want to sell 50 by 100. Of course, we write the necessary, agreement and so on, and I give to that person, meaning that the original document will still be with me. Is that the position of the law? Okay, if the original document is with me, and I now decide to sell the remaining 50 by 100, that original document, will it leave me and go to the person that's not buying?
Yes, of course, because you no longer have anything to sell, anything to transfer from that land. The last person that buys that land, interestingly, will be in possession of that original document, because the former one didn't buy the entire land. Because he didn't buy the entire land, he could not have asserted or ask you to give him the original, because if he does, with what would you sell the remaining one? So it's just a simple logic. So it is the second person that in most cases will be with the original. You understand what I'm saying? So because as at the time you bought the land in question, part of it still belongs to the owner of the land. So you cannot ask him to. So it's a simple decision.
Okay. Now let's move to one very interesting thing that most people have been saying. You hear that, of course. You hear Mr. A will say, of course, I have a CFO, and Mr. B will say, of course, I have a CFO, and so on. So many persons, do not actually know what a CFO, is all about. All they know is just to acquire land, and it ends there. So, Obosola Efo, please, can you educate our viewers?
Well, the full meaning of CFO is Certificate of Occupancy.
Yes.
Now, the government gives CFO. That's Ministry of Lands gives CFO. When you acquire a land, after acquiring that land, if you want to transact with that land, it's possible you want to start a business. You have a land, there's a house there, or even if there's no house there, but you have a land in a very good area. Now, you want to access the bank for loan. You want to access loan facility from the bank. The bank will only give you that money if you have a CFO over that land. Because when you have a CFO over the land, it means that it is recorded in the lands registry. It's there. So by the time it's recorded there, like now in Edo State, you have Edo GIS, it will be recorded there. So the ownership of that land will be there. So the bank that is going to give you that loan will be able to know everything concerning that land. By the time they do their searches, they will know we have searches. They contact their lawyer will go there and do searches. Then the history of the land will come out. Then they will not be able to determine who actually owns the land, whether the land actually belongs to the person that said belongs to him. If it's actually the person that has a C of O over that land. Then if there's a lien over that land, that's if there's a problem that land, maybe the person has used it to borrow money before in the bank, it will be there that he used that land to borrow money. So you will now also find out, as a lawyer, you will also find out whether that loan has been repaid. Because if there's a lien over that land, of course he cannot use it to transact another business without settling the loan he collected from the bank. So the C of O helps you, because no bank will give you a loan if you don't have a C of O over your property. So that one kind of also solidifies your ownership right over the land. But I must warn, C of O is not sacrosanct. It's not sacrosanct. Now, you can be in your house. There are always mischievous people. Like there's no society where you don't have the good, the bad, and the ugly. So somebody could just go and get a C of O over your land without you knowing. You get the point? Now, if the person that gets a C of O over your land, some people feel that when they get C of O, that's the end. It's not the end. Because if you are not actually the owner of that land, you now go and maybe you go and buy a land from somebody, then you now quickly go and put a C of O over that land. Then probably the person you followed in buying that land, you transacted with, is actually not the owner of that land. That's why we have land speculators. There are land speculators everywhere. Now, after selling, the original owner has already sold to somebody else. Another land speculator in communities, they will not go and sell the land to somebody else. You understand? Then only for that person they sold it to, the second person they sold it to, we go to Ministry of Lands, apply for C of O, and the C of O is given. Because first of all, when you apply for C of O, they are going to publish in the newspaper. But between I and you, how many people read the newspaper? So at times, it might escape you. You will not know that it's even your land, that they already advertised it. You understand? So but by the time you now become aware, that person has a C of O, but you have a better title. For instance, you want to acquire a land. You acquire a land in 1980 from somebody. You started farming there. Then, in 1985, a land speculator sells the land to somebody else. And meanwhile, he is not the owner of the land. He forges document and sells to the person. Then the person now puts a C of O. Then, of course, what do? You go and meet your lawyer. Your lawyer will do all this investigation for you. Then your lawyer takes the matter to court. Then one of the orders that the lawyer is going to ask the court to do is the court to prevail on the land registry, as the case may be, Edo GIS or Ministry of Land, to revoke that C of O that was given to you because you got it through fraud, through deceit. You understand? Because that land is not for you. By the time the original owner is able to prove before court that I acquired this land in 1980, these were the documents that were given to me. This is my vendor. Or these are the weaknesses that witness the transaction is documented. So this man is not the owner of the land, and you are able to prove your case actually that you are the owner of the land. Then the court has no alternative than to revoke that C of O. So C of O can be revoked if it is gotten illegally, unlawfully, or through deceit, or through fraud.
Okay. So, Jonathan, of course, Oifo just highlighted some reasons why a C of O can be revoked. Apart from the reasons that, of course, you just highlighted, are there other reasons apart from these ones that will make the authority to revoke a C of O?
Well, if you acquire a C of O, it's a of occupancy, and you should be very careful. Look at, because there are covenants in that
C of O.
In that C of O. Just as you have covenant, that's terms and conditions in everything. There are covenants. Covenant means agreements, terms of agreement, that are adumbrated, seriatim. That is to say, they are stated step by step, seriatim, on that certificate of occupancy. You check a copy of it. When you are applying for a certificate of occupancy, they will ask you questions that look very harmless. You'll be answering them. They'll say, put yes, put no, put yes, put no. Is this certificate of occupancy? Is this land going to be used, for example, if we issue you this certificate, is it going to be used for what purpose? They will now list them. Commercial, residential, this, that, farming. You begin to tick them. If the government is not happy with you, one day they can just wake up and say, this land is a residential, this area is supposed to be a residential area. Why did you now put a commercial, or you built a hotel here? It happened some time ago, not under this government. We know, we don't mention names here. Some hotels were being threatened. They will close them down. You go and build a school in where a school is not, go and build a market in where a market is not supposed to be. You are at risk. That's why if you do things that are contrary to what
the terms
what are contained in that covenant contained in that CFO, then of course they will revoke it and nothing ever will not fall. Then you are also required to pay. You pay like a tenant. You see, when you acquire a CFO, you are a glorified tenant for the government, so to say. I'm not discouraging anybody, but I want us to be aware that this is what I'm buying, this is what I'm entering into. So once you apply, every year you must pay rentage.
Ground rent.
You call it ground rent. If you don't pay, what happened to some people in Abuja, including a very well-known political party, one of the largest political parties in Nigeria? What happened to them will happen to you, because the present minister of Federal Capital Territory, Abuja, revoked even a certificate of occupancy of his party. So government can go as far as that one. So apart from this, apart from the fact that the root of title, like my learned friend rightly pointed out, is incurably defective, or that it is non-existent, your certificate of occupancy can also be revoked by a flagrant disobedience or breach of the fundamental terms, the one we call covenants. There are fundamental terms in that certificate of occupancy, and if you breach them, the law will nullify it.
Okay, if you breach
through court.
Okay, the law.
And the executive that issued it can even take it away. You go to court.
Okay, a while ago you highlighted some very strong reasons why a CFO can be revoked.
Yeah.
And now I'm back to you. I want to find out, apart from you have highlighted and you have educated members of the public, now can you also tell members of the public, what are the things that make a CFO to be valid?
Well, it's just the opposite of what I've just said now. Because if you acquire the land lawfully, then it makes it valid. Then, just like my learned friend has said, if you don't go against the terms of the CFO, because like now, you are supposed to pay ground rent. You are not, if that place is designated as a commercial area, then you now go and, or as a residential area, then you now go and turn it to a commercial area. You could even start a club there and all that. The government has a right to say, yes, this CFO was granted you based on the fact that that place was supposed to be for residential purposes. Now you have turned it to another thing. Because when government designates an area for residential purpose, you cannot be having a clubhouse within there. Because at the end of the day, a man goes to work. he comes back home, he's expected to have his sleep in a quiet environment. Then you're not going to put a club there that will always be constituted as nuisance. You see that the government somebody could write a petition against you, and the government will go and look at your papers over that area, and they will not see that you were granted a C of O for residential purposes. Now you have turned it into a commercial, so they have a right to revoke. You understand? So there are issues. It's just like also the government also has a right. You could even have your C of O, you could have the necessary document and all that. The government also has a right to say yes, they want to compulsorily acquire your property, even if you have a C of O. But then they will compensate you. The law says that before you now compulsorily acquire somebody's property, the government has to pay compensation. And if you are acquiring it, you should be acquiring it for the overall public interest. You are going to use it for overall public interest. You understand? It's not, the government does not just have a right to say they come into an area, you have already built your house, you are living there, they will now come and say, we have revoked your CFO, we have taken over this land. They must pay compensation first, and they must use the land for overriding public interest. For instance, maybe they have looked at the community. There's no health care, no health center in the community, there's no hospital. And they want to build a hospital that will be beneficial to everybody. And there already houses there. Okay, they want to build a stadium in an area. And people already acquired land around, including those that also took a C of O for their property. Government will now compensate you. It's there in the constitution. You understand? They must compensate you. And if government now goes ahead, maybe after acquiring that land, you now go and start using it to patronize other government officials. Maybe politicians, after acquiring it, you start giving it to your cronies, to your political party members, and they will start now building private homes there and all that. Then the person can take the government to court. Now, because when you acquire this thing from me, the law says that it must be for overriding public interest. You cannot compulsorily acquire my property, and you say you want to build a school there. At the end of the day, you go and give it to an individual that will build this mansion there. They build whatever they like. So the law protects everybody. That's the beauty of it all. That probably people are not implementing it, or they are not going to the court to assert their right and to acknowledge the wrong that has been done to them and all that. That's why we have all these problems. The law takes care of everything. You understand? So for you to have a CFO to make it valid, you must abide by the terms and conditions of the CFO. It's very important. And the advantage of having CFO is that when you have a CFO, of course you can always approach the bank for a loan. The bank will give you. Because if you say you have a house and there's no CFO over it, or you have a land, there's no CFO over it, the bank will be very, very reluctant to give you a loan. Because what are they? How are they not going to investigate to find out? Because they're going to give you other people's money. That is in the bank. So they must ensure that loan is secured. If you are asking for a loan of 100 million, they should see something that you have that is more than 100 million if they sell.
Okay. For you to enjoy your CFO, of course, you must respect some of
the terms and conditions.
The terms or the conditions, contained therein. The program, The Law and You, will be back in a moment. Stay with us. Yes, you're welcome back. In case you are just joining us, the program is The Law and You. It's a program designed by the management of Edo Broadcasting Service. to educate members of the public with respect, to the fundamental human rights, and we also look at the law in totality. We've been discussing the topic land acquisition, and now over to you and Jonathan. Before the application for a CFO and the certificate of occupancy, is granted, are there conditions that somebody must fulfill before the application, can be granted, sir?
Yes, of course. Before, as you apply for a CFO, you must have these things in place. You must, one, have a valid survey plan. When I mean valid, it's not the type that they will just write draw on a piece of paper and give it to you. That survey plan must be lodged.
Registered.
It must be registered. That's lodgement with the deed registry or the appropriate authority. Just you lodge it. Then two, they will ask you for the root of title. In this claim, they will either ask you for Oba approval or community approval or any other thing, which of course is always attached to the agreement that lawyers will prepare for you. Then, if you have that one, initially, let me correct the impression, because some people might now be having the impression that since a customary something, they got it customarily. With what document are they going to do the CFO? It's not like that. These days, we have passed that ancient times where things were not actually documented. So what they do these days is to do an approval. Even communities these days, just do approval to show that this land has begun to so and so person. He applied. And by reason of that application, we gave the land to him. We sold it to him. Then Oba approval, that one has been there for a long time. The Oba will get an approval, will give approval to your application for a building plot. Because, mind you, the Oba of Benin, His Royal Majesty, he stopped at the time of His Royal Majesty Oba Kenswa, where was the sole trustee of all communal lands in Benin City and environs before the promulgation of the Land Use Act 1978, which is now that it was land use decree that time under the presidency of military presidency of Olusegun Obasanjo. Then after that time, it ceased to exist because all land now belong. They are no longer under the trusteeship of the Oba or the traditional institutions. They are now placed under the governor of the state. I think these are matters for another day. The governor now have this land in trust for the people of the state. So they will ask you to produce that one. That time, Oba approval was even, and it's still a registrable instrument under the Land Instrument Registration Law. So you register it. So even if we say they were customary, there was a way they could still put it in a writing form, so that for evidentiary purposes anyway. Then the one they will now ask for again is the document by a lawyer.
Yeah, the deed of transfer.
Either the deed of transfer,
conveyance,
or the deed of conveyance, or the deed of assignment.
Yes.
These days, the thing is very tough now because the Bar Association, Nigerian Bar Association, Association of Lawyers, has even had a synergy now and to implementing the law which has been there for a very long time. We were not born when that law was there under the Land Instrument Registration, Land Instrument Remuneration Law. Mm-hmm. So you pay 10%. We are not here to talk about that. Compulsorily now, Nigeria Bar Association will stamp, the lawyer will stamp. You can no longer woodwick anybody to say, I'm paying less. And if the lawyer charges less, the lawyer will face punishment under the law. You understand? So that is the situation. They will ask for that. They do GIS. They do geographical. They will ask for it. Then, upon that, upon the production of those ones, they will now ask you to pay a registration fee. And once you pay, they will now go for investigation, either physically or they do it in any form. So they could use Google Map or whatever to ascertain the location of that land and all that. So by and large, if all those things were not, if they are not there, and if they are found to, from their investigation, they are found not to be genuine, they will not go ahead with it. I did a particular one around the Ogba area, airport road area, down airport road area, and the government, it got to a stage, the DOJ said, they wrote us and said, we are sorry that we can no longer go ahead with this registration because we found out that it is a land owned by government. So we cannot issue CFO to anybody on the government land. So once they found that that the land is a Kubrand, I mean, that is to say there is something on it. For example, used for loan, as my learned friend said, or that is a government land, or that the land is being litigated upon. Maybe the land is in court. You cannot register a land, the subject of which is litigation in court. You cannot go and get a CFO over that land that is already pending. That is, the ownership is already pending in a court of competent jurisdiction. So all these things must be there. You understand? Even after you get that CFO, like has been explicitly made out here by my friend, if it is discovered that somebody got it earlier, because in law we say where equities are equal, the first in time prevails. That is to say, there's seniority in it. If I got my land in 1985, and you are now coming by 1990, you said they gave you the same land. If evidence is laid to show that that land was initially given to me, the CFO which you had, we have set aside so many CFO, will be set aside by court, through court. You understand? So that is how it is. So all these things must be in
Okay. And let me now talk to Ebosele. Sir, there is this something that is bothering the minds of Nigerians, living in Benin City, and that is the issue of the alleged activities of Community Development Association. It's alleged that some communities are practicing CDA even when it has been banned by government. And so I want to find out from you, as a lawyer, looking at it from the eyes of the law, what is the punishment in the event that somebody is arrested practicing what has been banned by government?
Yeah, well, it's a very straightforward answer. If even when you are not talking about land, when you go against the law, there are punishments, and you undergo that punishment. Now, because of the attitude of CDA, the government now outlawed it and promulgated the law. The House of Assembly passed a law. It came into effect. In fact, they were even sitting in government house then. I think they are still sitting in government house there. And all that. So if you don't have a right to encroach on another person's land, you don't have a right to go and be fighting somebody that is developing a land. You don't have a right, the person is developing his land, then you go there and damage the land and all that. There are punishments for various punishments. Yes, you could be sentenced to jail for like 7 years. You could even be told to pay fine, option or fine. There will be no option at all. You go in for it, and all that. So the government has already put this law in place. So, but what we keep saying, they say ignorance of the law is not an excuse. People are reluctant. Some people, they don't want to wait. The next thing, government already banned CDA. You see them coming around to still do the activities of CDA, they still carry it out. But the government cannot do anything about it. Do you know why? Because people are not complaining. You understand? Because if somebody, you are developing your land, you've already paid for that land. You have paid the community what they call a molu here. That's, because you must pay a molu. The road that you take to your land, if it's not tarred, and the community, they maintain it. There's light, At times they also provide security and all that. They say, okay, pay a molu, which the government also recognize. You understand? Now you have paid all that. You have paid what you are supposed to pay for the land. You have also settled. You have also gone to Ministry of Lands. You have paid for your building plan. Your building plan has been approved. Then you are now building, and some people will now come out and say, "We are CDA. Come and give us money." So some people will just say, you know what people always are afraid of? They'll say, because I'm going to stay in this place, I don't want any problem. If I don't pay them money now, they might come and be attacking me up and down. But that's not true. You have to make use of the law. You have to lay a complaint against them. You don't even need to write petition to the police. Because if you write the governor, you will write Commissioner of Lands and all that, they will come into it. And those people will be arrested and they will be prosecuted. You understand? So the law is already there. But our people don't take advantage of it. Because they will look at it, which time will I have to go to court and be doing all that? Let me just pay the money and move on. And that is why it's still prevalent. You understand? Because people are not being shown example. They are not being arrested and used as an example to deter them from doing what they are doing. That is why they are doing it. It's not as if the law is not there. The law is there. So, but people should be able to, everybody is supposed to have a lawyer. You are supposed to have a lawyer. When such issues come up, you go and meet your lawyer. And the lawyer knows what to do. How to do about it. Somebody take over your land, then, you don't even need to be bothering the police with that, because the police have no authority. They don't have no jurisdiction over land. Anything that is civil, the police doesn't have any problem there. The only issue police have is the criminal aspect of it. Maybe you go to the person's land, you want to kill the person. Of course, the police will be involved, because they have to prevent you from either committing manslaughter or murder or disturbing the peace. You understand? So, but what people should do is that when you have a land and you are being disturbed, meet your lawyer. Your lawyer knows what to do. The lawyer will immediately take the people to court. And at the end of the day, you get your land back. Okay, the money that you also use, you will claim damages. So there have been, let me just land. There have been instances where the person will, you get a judgment and you are giving damages. I won one land case the other day, and damages of 2 million naira was awarded for my client. You understand? So at least that one takes care of all the problem here and there. So people are not taking advantage of the law.
Just told us now that the police, of course, they have no business, with civil matters. That when you have any land issue, that of course, you don't even need to even go to the police. But again, when you go to most police stations now, of course you see, people coming there to, lodge complaint about, one man or one woman, trespassing their land and so on. So in this regard, what do you have to tell our viewers?
If there's an infraction, if somebody is encroachment on your land, then don't hurry to go to police or any other institution. Do you know, at the time, people were ever going to military barrack, to go and bring army. So I'll just bring army I will just bring soldiers to come and fight, to come and drive you away from here. So when eventually you are there, and somebody is encroaching on your land, meet your lawyer, and the lawyer will know what to do. If you want to do it yourself, nothing precludes you, provided you do it the right way. You go and report. You do a petition to the appropriate authority. Or you just go and put the law in motion via the court. The court will now give you judgment and ensure that that land is given back to you. Sometimes award damages. So when you patronize persons or authorities that have no power to do a particular thing, I always think that you believe in jungle justice, self-help, instant justice, and which is not found anywhere. The due process must be followed. In this our climb, in this our jurisdiction, most people want it very, very urgent. They want to make justice hastily.
Jonathan, I'm afraid
want to get justice hastily.
because of our time. Of course, we need to end it here. I'm very sure, of course, you know, I think we need to meet again to continue this this topic. And so, viewers, is on that note we want to, you know, draw the curtain on the program, The Law and You, and we have been discussing land acquisition. And I have two gentlemen, of course, that have done justice to this topic. Ebosele Oyifo Esquire is a Benin Place legal practitioner. Thank you so much for your contribution.
Thank you, Oliver.
I also have Jonathan Anelwa, is also a Benin Place legal practitioner. Thank you so much, for your contributions.
Thank you. We thank our viewers too.
Yes, if you have any complaint, of course, with respect, you know, to your land, of course, meet your lawyer, because they are the ones that will handle this matter, you know, for you. And it's not in your place, of course, to